My name is Hillary Sklar. I'm an attorney with Disability Rights California. We are a statewide nonprofit that provides legal services and advocacy to Californians with disabilities. We have 5 regional offices throughout the state. They're located in Sacramento, Fresno, the Bay Area, Los Angeles, and San Diego. And at the very end of the presentation is our toll-free number, so that you can contact the office closest to your office in your catchment. And also on the first slide, I've given you my email address as well if you have questions after the presentation or in the future. So for today's presentation, I've selected the following topics. One is, what are the obligations of nursing facilities to provide assistive technology to its residents? Number 2, what are the potential sources of funding for assistive technology? Number 3, what are some common barriers to obtaining assistive technology and how to overcome those barriers? Number 4, I will talk about advocacy, your role as advocates in working with consumers to make the case for the equipment that's needed to get a strong evaluation and what to expect during the process. And the last topic is the appeal rights of the nursing home resident. And as Rosemary mentioned, there will be some stopping points throughout the presentation for questions. Okay, let's jump in. I think just as a framework, we are talking about nursing home residents who receive Medi-Cal. That's the California's version of Medicaid. And to keep in mind throughout the entire presentation will be sort of what is the relationship between the nursing facility's obligations to the residents and the residents' rights, and the residents' rights under Medi-Cal, and how do the two work together or not. So the first law we're going to look at is the Federal Nursing Home Reform Act. And I provided you citations throughout the presentation, and at the end of the PowerPoint, I've provided you a link to where you can find the Act and then move around to find various citations if you need them. So under the Nursing Home Reform Act, nursing facilities have many, many obligations towards their residents. I have selected the key ones for our AT purposes. The first one is that the nursing facility is required to conduct a thorough assessment process. And this assessment process is larger than assistive technology needs, but should include a resident's assistive technology needs. So the facility staff must conduct a comprehensive, accurate, standardized, meaning that it is applied resident to resident, of the resident's functional capacity, and that describes the person's capability to perform their activities of daily living and any significant impairments they have, and to identify any medical problems. When are nursing facilities required to conduct these assessments? Many times during the course of the person's stay at the facility. First, upon admission, they must promptly conduct this assessment. They also must conduct an assessment whenever there's a significant change in the person's physical or mental condition. And if that does not happen during the course of a year, then they must at least do this once a year. Who is required to conduct this assessment? The law requires that an appropriate licensed professional must do it. They could do this with a non-licensed health professional. It should be, we want to see like a doctor on board with this, not just a nurse at the facility. And the resident, very importantly, the resident has rights to be part of the process. So it can't just happen in isolation without knowledge of the resident and without the resident's input into what their needs are and what their impairments are and their abilities. The assessment must look at communication, vision, mood, behavior patterns. We want to look at the psychosocial well-being of the resident, their physical functioning, how is their health, do they have any dental needs, how is their skin doing, is there any skin breakdown, what are their medications, what's the potential for discharge, because separately there's obligations of the nursing facility for discharge planning. And what are the residents' interests? What activities do they engage in? Do they want to engage in? What activities can they engage in? And that includes in the facility, inside, and also outside of the facility, away from the facility. Are they actively involved in any community activities? Do they have a social network where they like to go out in the community and go to a restaurant, go to the movies? Does their family come to visit? What's the reality for activity life inside and outside, so it's not just that the resident stays in their room all day and likes to watch television, which may be true, but we want to also see and know, does the resident want to do outside activities? And then what are barriers to those activities? For example, I worked with a client a number of years ago who had multiple sclerosis. At the time of her admission, her MS was so advanced that she otherwise was rendered bedridden, but needed a proper fitting, proper sized wheelchair so she could move about. With such a wheelchair, then there were very few barriers. Without the wheelchair, she was stuck in bed all day. We ended up getting her the wheelchair she needed, and she wanted to be in the community. She wanted to ride the metro rail. She wanted to go to the store to get her own personal items. She wanted to go to restaurants. She wanted to go to the movies. And as a nursing facility resident, she has the right to do all those things. The barrier was the needed wheelchair. So to kind of bring home this point about assessment plans and care plans, we want to see that it is thorough, it is looking at the resident as a whole, and also includes an assessment of any AT needs. In addition to the assessment, the facility staff is required to produce a plan of care. How will the residents' needs be met? And that includes the same topics as I mentioned earlier. So once we assess, the person is assessed, what is the connector to meet the needs? And I want to highlight the second bullet point at the bottom. This is the standard that the nursing facility will be held to in conducting the assessment and developing the plan. It is a very broad standard, and it's very important for us as advocates to keep the standard in mind. The facility is required to provide services and activities to attain or maintain the highest practicable physical, mental, and psychosocial well-being of each resident in accordance with the written plan of care. What this means, and I can't emphasize this enough, is the resident has a right to be assessed and treated as a whole person, not just someone with medical needs. But as I mentioned earlier, what are their interests? What do they need to be able to achieve those interests and activities? So we want the nursing facility to take into consideration their physical needs, their mental needs, and their psychosocial well-being. Example of psychosocial well-being is the right to be able to go outside of the facility when the resident wants to, not just when staff is available, but to have the independence to move about the facility and outside the facility when the resident chooses to do so. And the written plan of care is really important here when it comes to requesting AT that will help the resident achieve that independence. I'll speak more about the standard a little bit later in the presentation. So on this slide, I've restated the standard again, and also want to point out that nursing facilities are required to include rehabilitative services, and this includes physical therapy, speech and language services, occupational therapy, and mental health services as well. And the physical therapy and the speech and language and occupational will come into play, particularly with getting the AT that is needed. So again, the nursing facility must provide services that will take the person into account in their whole being to enable independence and full participation. And the resident has a right to make choices about their lives, choices about their health care, choices about the activities they engage in, life inside the facility and also outside in the community. And also, a right that can come into play when asking for AT is the right to participate in social, religious, and community activities. For example, a resident may be an active member of their church or synagogue in the community, and at the time of their admission they were really active, but now that they reside in the nursing facility, they may not have the equipment they need to get into the community. So it is important to underscore and mention when we're providing advocacy all the activities that the resident wants to participate in, and we want to make sure that all of those activities are in the plan of care, because that will show that the nursing facility staff had knowledge about the person's interests. So if there's difficulty in obtaining equipment, we want to be able to show the connection. The resident expressed interest in the following activities. The nursing facility has knowledge of that, and we want to scrutinize what is the nursing facility's obligation to help meet those goals, those activities through AT if needed. So the Nursing Home Reform Act is very comprehensive, and I just selected key points for today's presentation. So don't think that I've covered, this is not a presentation in the Nursing Home Reform Act, but I wanted to highlight key provisions that are useful in our advocacy for obtaining AT equipment and services. I see at least one question so far. Question is, I have a consumer who has now contracted legs. So I think that means leg contractures, and that the nursing facility said that Medi-Cal only pays up to 100 hours. I'm going to guess that you mean for physical therapy. And I would have to look up with the regulation, or you could do it yourself. The key is to always look up when Medi-Cal or other state agency answer with, no, we won't provide this service, or yes, we will, but there are limits. We always want to ask Medi-Cal, what is the law, what is the regulation that you are relying on to assert this? So my first question would be, did Medi-Cal provide a regulation? And secondly, need to look up that regulation to see if that is correct. The second part of the same question, I think, from Alicia. Client has MS, and the power chair given by Medi-Cal is not good for her anymore. Nursing facility says they won't give her the chair until October. So I would want to know, why is the nursing facility saying she has to wait until October? When did she receive the power chair, and who paid for the power chair? Was she a resident at the facility, or any facility, at the time that she received the power chair? So follow-up part of this from Alicia is, client is scheduled to leave the facility in less than 1 week. So this raises a few issues. One is, does the nursing facility have obligations to provide equipment that will be needed in the community? Or is this client in a better position to obtain the equipment once she is discharged from the facility? Will she be able to be independent in the community, or will she not be until she receives a proper fitting power chair? I'm not seeing a follow-up question, but those are the issues that these facts raise for me. What is the timing? Who is responsible? And what is practical? Is it practical to ask for a wheelchair and get discharged around the same time, when we know that it can take months to get equipment, sometimes more than a year? So I think at this point, with this fact pattern, see, Alicia, is ILR, is that inland? I'm not sure which part of the state you work in. San Francisco. Okay, so that would be our Bay office. We can talk offline more about this particular fact pattern so that I can continue with the presentation if that works. But for everyone else's purposes, I think that what's important about this fact pattern is spotting the issues and asking, the who, what, where, when, and how. What are the residents' rights? Who is responsible? Why is there a denial? Is the denial proper? What advocacy is needed? If there are no other questions, I'll proceed with the presentation. Question from Joe: who enforces this? Who enforces? I need a little more information with your question. What is this? If the nursing facility is not complying. If it's a question of equipment that could be funded by the facility or Medi-Cal, we'll talk about that a little later in the presentation, because it depends on what equipment is being sought. So I think I will get to your question a little bit later in the presentation. Any other questions before I move on? Okay, I'm going to move on to the next topic. So in California, there are a couple options for funding. But again, as I mentioned at the beginning, the framework is really, is it the nursing facility's responsibility, or Medi-Cal's responsibility? And just as a note, the nursing facility is using Medi-Cal funds, the question is, do you make the request to the nursing facility directly, or do you go directly to the Medi-Cal field office? There's also an option for residents to contribute or flat out buy equipment they need and bypass the whole system using their share of costs, and I'll talk about that in this section. And I just wanted to note that Medicare rules do not apply here in facilities because Medicare ATs limited to in-the-home use, and in-the-home use does not parlay into my home is a nursing facility. So we are interested exclusively in the Medi-Cal rules. So the sort of kind of sound bite, if you will, is that for non-customized assistive technology, we're going to look to the nursing facility directly. Nursing facilities receive per diem funds from Medi-Cal called per diem rates, and Medi-Cal looks to the facilities to use these per diem funds to buy equipment that's needed by their residents. And examples include wheelchairs, medical equipment, some prosthetics, and under some circumstances, augmentative and alternative communication devices like speech-generating devices. What's the most important to remember here is nursing facility equals non-customized. So this is equipment that is interchangeable, that other residents could use in the facility, that does not need to be tailored to the resident and their specific disabilities and needs. So one example could be a speech-generating device. On the one hand, it may be programmed and tailored for a particular resident, but because it's programmable, it could also be used by a different resident. And I don't mean that they should have to share it, but what I mean is once the facility purchases it, if that resident is discharged out of the facility or doesn't for some reason otherwise need the equipment anymore, it is a device that could be used by another resident. Wheelchairs are another example. Nursing facilities can buy off-the-shelf wheelchairs, reclining chairs, and have them available for the residents. For some residents, those might work fine, but for other residents, the standard equipment will not work. So then the question is a nursing facility obligated to provide customized equipment that needs to be tailored to a specific resident? And the answer is no, but they have a large role in helping the resident acquire that equipment. For customized equipment, and here I'm going to speak mostly about customized manual and power wheelchairs, because I think those are a really good example of equipment that often needs to be tailor-made and made with specificity to address a client's disabilities and medical needs. Also is a site of many denials by Medi-Cal and facilities as well, as we saw in our earlier question. So in California, Medi-Cal is responsible for directly providing assistive technology. And the rule is when the equipment is custom-made and necessary to meet a unique or unusual medical need. So it's not just any equipment. It has to meet this custom and unique and unusual standard. Here, custom means that the equipment is constructed to address a particular medical need of the resident for positioning, support, and or mobility. So an example would be a client that I had 2 years ago, a young fellow with cerebral palsy, and he had upper and lower extremity paralysis, and he had upper and lower extremity contractures, and he had scoliosis and very poor hip flexion. He could not sit in a standard off-the-shelf wheelchair. He did not have the muscle control to sit upright on his own, and his body, there was no way to seat him in a manual chair or even a reclining chair that was not custom made for him, because of the paralysis and the contractures, and because his hips just did not move. He didn't have control of his hip positioning. So there, his chair had to be constructed to support his positioning needs, to meet his body where it wanted to be. And that also included cushioning to prevent pressure sores. Unique and unusual means a medical condition or disease that is made worse by physical characteristics of the person, their height, their weight, their body build. But what's important to note is that the existence of the physical characteristics by themselves are not enough. The characteristics in medical, there has to be a connection between a medical condition and the physical characteristics. So here, with the client that I mentioned, the physical characteristics were the paralysis, the contractures, the very poor hip flexion. But all of those together created a medical issue for him. Because he could not sit upright, it put strain on his muscles, on his back, on his hips. Because of the paralysis, he could not independently relieve pressure, and so needed equipment that did it for him. A chair that could tilt and recline, and open him up where he could not open up his sitting position by himself because of the paralysis, because of the contractures. So we had to argue the connection, not just the fact of. And for custom equipment, the equipment is requested directly to the Medi-Cal field office via the treatment authorization, the TAR treatment authorization request process. And I'll speak on the advocacy piece of the presentation. I'll speak with specificity about that process and how one asked for equipment. A third possible funding source is for the resident to use their share of cost. And they can use this to obtain equipment that Medi-Cal does not cover, or that Medi-Cal does cover, but they don't want to wait for the process to happen and have the funds available to pay for it. So it could be, if there's a limit on physical therapy, they could possibly use their share of cost to purchase additional physical therapy sessions. I provided a link to an all-county welfare department letter that talks about this process at the bottom of this slide. And a resident has to get a doctor's prescription for the service or equipment. So it's the same process as other AT, and we'll talk about that momentarily. But the resident can't just sort of act on their own. They have to still work with medical staff and the facility as well to let them know what they're doing. But it's an option, not always a viable one, but is an option to act with more independence in the process and to supplement the technology, the services, the care that is available or may not be available in the facility. A note about share of cost. I think it's important to look at this all-county letter. It may not be practical for a resident to go this route, but it's a route that should always be explored when doing the analysis of what are the possible funding sources available. Any questions about funding? One question from Alicia: would Medi-Cal pay for a rental when waiting for equipment? Possibly. Typically, vendors of equipment are looked to provide rentals or temporary equipment. The problem I've often seen is that vendors don't have the customized equipment. And so while it might be correct to say vendor should provide, assumingly funded by Medi-Cal, though I have seen vendors who couldn't get the funding and just acted alone and basically just loaned equipment to clients. The issue is going to be, will that rental equipment meet the person's needs? And if they need customized equipment, the answer will probably be no. And if the person can make do with that equipment, I would be really careful to explain, to document if needed, how it is that client can make do with the rental equipment while they are seeking more customized equipment. I'm making an assumption about your fact pattern, but when our clients need the tailored, customized equipment, we have to be really careful about making do, because making do with equipment either means that they can really use that equipment, or may mean that equipment could cause other problems. Yes, they could make do possibly for a very short term with an off-the-rack wheelchair, but maybe due to their seating position, or if they have contractures, that equipment may actually cause harm. Does that help with your question? Okay. Any other questions about funding? Okay, I'll move on to the next section then. So here's a list of common barriers that we have seen to getting equipment. And again, my framing of this presentation is around customized equipment in particular. But I think this could apply and does apply across the board. And there are two sets of players. One is three sets of players: the facility and their knowledge and their interest or resources to assist with getting AT. Also the resident and their own advocacy and knowledge about their rights. And then the role of Medi-Cal. So first, under the facility, we have seen a lack of awareness and skill with facility staff. And this means the facility may broadly know of their obligations to their residents, but maybe have not had the opportunity to help a resident obtain, really customized, highly customized equipment. And so it may just be well-meaning, but we really don't know what to do and what our role here is. I've also worked with staff at facilities that are very knowledgeable and are very interested in advocating and assisting their residents, and also just needed some guidance of how does the process work. Do I do this internally through the facility and go to Medi-Cal, as facility staff, or how do I work with a vendor to help this resident? How do I work with a physical therapist? Do I have to? So sometimes it's an issue of providing technical assistance, if you will, to the facility staff themselves. What is their role and how can they work with this resident? Other times, and sometimes in conjunction with, the resident doesn't know what their rights are and doesn't know how to go about getting the equipment, what the timeline should be, what they can expect of the process. How do they work with their own doctor? Can they work with their own doctor? How did they find a vendor? What if they worked with a vendor in the past that they really liked, but they were placed in a facility that's nowhere near where they lived, and so they don't know the community? What's the role of family members in helping the client advocate for the equipment they need? And then secondly, the role of Medi-Cal. And again, this, we're talking about custom equipment. And we have seen requests denied for a variety of reasons, but they usually fall into the following categories. Medi-Cal says, no, we are denying direct funding of this equipment because the nursing facility is on the hook. They are responsible for providing equipment that's needed by the residents. So we are not part of this process. It's through there. We give them the per diem funds, and the facility must go and do this. They may not say must because per that particular piece of equipment, so it's not necessarily an acknowledgement from Medi-Cal that yes, the client does need that equipment, but they will strongly assert that don't come to me, go to the facility. Another common denial we've seen is that the facility already has equipment that will meet the residents' needs. And so the question is, does the facility have that equipment? One, Medi-Cal, what is your knowledge about what equipment the facility has? Are you making an assumption that every facility should have a certain number of wheelchairs, for example? Or do you have specific knowledge about this specific facility and the equipment that they have? The other side of that is resident advocate. What is your knowledge about the equipment the facility has? Has the resident tried out the equipment that is there? Has the facility offered up that equipment? Did it work? Did it not work? And what is the reason why? Because Medi-Cal's not wrong in saying that the facility has a responsibility and that they may have equipment, but the advocacy comes in showing why that may or may not be correct as to this resident. So, for example, with the client that I mentioned earlier with the cerebral palsy, Medi-Cal said, it's not our responsibility directly, it is the facility's responsibility, and by the way, they have wheelchairs there that can meet his needs. And so, as part of our advocacy with him to prepare for his hearing, we went to the facility, we asked to see all of their wheelchairs. We asked the client, have you tried them? We asked the staff, have you offered these to the client? and did he sit in these? What happened? And we asked the expert, the physical therapist who had assessed him for equipment, what is your opinion of this equipment? Number 3, Medi-Cal may say the requested equipment is not needed because there is staff available 24 hours a day, 7 days a week to assist the resident with their mobility. It may be true that staff is there 24/7, but it may not be true, and it is specific to the resident, that the staff can meaningfully assist them with their mobility. What's missing in this denial reason is that the resident has a right to move around when they want to, not just when they can get help doing so. So if a client can't transfer independently into a wheelchair, then it's meaningless. If a client cannot use a power chair and therefore requires a manual chair that is customized, but can't, maybe that client can independently propel themselves. Well, then we've got something. But if the client cannot independently move around in that equipment, it gets a little trickier because maybe Medi-Cal is correct in saying that the facility staff is there to help them with their mobility, but that doesn't mean the client doesn't have a right to proper fitting equipment. This is often a reason we see with denying power chairs, for example. Number 4, the request made through the TAR process does not establish a medical need. This may or may not be true, and so it requires a review by us as advocates of the TAR and what was the medical justification provided. And I'll talk about that momentarily. What I will say now is that the medical justification can make or break your cases. It may be true that the client needs a specific type of equipment, but if the justification is not there, if the facts do not prove the standard that needs to be shown, then all bets are off. So the evaluation by the physical therapist and what they put in writing is highly critical to this process. So it may mean getting a supplement to the evaluation that explains with greater detail what the connection is, what the medical need is, or it may be, upon review, that the medical justification really seems sufficient and Medi-Cal is wrong. And lastly, we've often seen that residents of nursing facilities are not kept in the loop of the process because they don't receive a notice of action telling them that the equipment had been requested and was either approved or denied. Medi-Cal recipients, regardless of where they live, have a right to receive a notice of action. That is, Medi-Cal telling them, we are taking the following action on this date, and this is the reason why. What we see is that Medi-Cal will send the vendor who made their equipment request a notice of action, but often does not, in some cases actually have, but often does not also send a notice of action to the resident, to the client. It is not a vendor's responsibility to send the notice of action to the recipient. That is Medi-Cal's responsibility. I see that there's a question, and I'll pause for it at the end of this section. So here's sort of some shorthand for getting custom wheelchairs. Now, I understand the issue may not always be custom wheelchairs, either manual or power, but I think this gives us a good framework for customized equipment, period. Because it is more likely to be a more straightforward process for off-the-shelf equipment. Not always, but more likely to be a more straightforward process. It's the customized equipment that takes longer, often requires more advocacy, and requires a significant amount of detail. So the first step is we want to get from a doctor an order or prescription for an evaluation. And if at all possible, we want that evaluation to take place at an accredited rehabilitation facility, compared to with a vendor, for example. Now, some vendors are certified to conduct the evaluations. That's better, but if at all possible, we want it to be conducted by a physical therapist who is independent of the equipment that they are going to recommend, so that the vendor, while they may have the proper training, may still be kind of limited unconsciously or consciously to the equipment that they have available in their company, versus a physical therapist who doesn't buy or sell equipment and merely conducts evaluations may consider a broader range of possibilities. So whenever possible, and it may not always be possible, but whenever possible, we want that third-party kind of independent actor, a physical therapist. And to get that evaluation, we need to go through the doctor first. And once we get that authorization for an evaluation for a client, and this is a process that the clients can do by themselves as well. It doesn't require us as advocates to do it. But if we're involved, then it's advisable to make contact with the physical therapist who will conduct the evaluation. Not to tell the physical therapist what to say, but to provide information about the process, and to offer information about the medical necessity standard and the broader Nursing Home Reform Act standard as well, and to explain that their job is absolutely fundamental to this process, and that it is really, we have seen it to be very effective when physical therapy evaluations or equipment evaluations, because it could be from a speech therapist, for example, have detail, connect the facts of the person and their disabilities, connect that to the equipment, and then address how that specific equipment will address the impairment. Number 3 is if the physical therapist is open to this, and they may not be, but if they are, ask for a copy of their report. The client can ask for a copy of the report. 1, to have a copy, and 2, to review it for thoroughness and accuracy, if at all possible, before it is sent in with the request to Medi-Cal. Just to have another set of eyes. Again, it is, our role is not to tell the expert, the therapist, what to say, but the client has an interest in making sure that all the information is accurate that is being said about them. Their age is correct, their body description, their height, their weight is correct, that their disability is stated correctly. It can be helpful. Number 4 is to work with all the players the therapist or speech therapist or physical therapist, the experts, and with the facility staff in promptly getting the equipment the request made for this equipment. Number 5 is related to number 4. So we will add to the players the vendor, because likely if the therapist is not also a vendor, then in addition to the facility staff, we now will add a vendor to the process. And so we want to encourage the vendor to act promptly as well in ordering the needed equipment. Number 6 is to keep an eye on what is the correct funding source. So if the vendor is making the request, for example, are they going directly to the facility? Are they going directly to Medi-Cal? And if this is customized equipment, we want the packet that goes in with the request to reflect it, to be absolutely clear. This is customized equipment. Medi-Cal, this one's for you. This is directed to you. This is to you directly, because nursing facility is not on the hook in the same way, because it is custom equipment. The request will always be sent to Medi-Cal, but it is important that it is clear in the request that this is customized equipment, to try to avoid some of the common denials that the nursing facility is responsible, that they already have equipment that is needed. So for example, in the evaluation, it would be very important if the client has tried the equipment at the facility for the expert to say that up front in the evaluation. The facility has the following wheelchairs available to this resident. This resident tried each of these wheelchairs, and here's why they didn't work. Or the facility does not have wheelchairs for this person to use. But to save time, it would be very important to put that up front in the request, to anticipate responses that Medi-Cal may have that we're going to have to fight later anyway. Number 7 is to keep in touch with all the players to make sure that the process works smoothly and in a timely fashion. If a TAR is not acted upon by Medi-Cal within 30 days, it's deemed approved by operation of law. It may require going to a hearing months later to try to enforce that, but that is what the regulations say. So if the vendor has not heard from Medi-Cal by day 29 or day 30 or by day 31, someone should be watching this. Number 8, it's to provide our clients with information about their appeal rights and also their rights during the for the whole process. How does the whole process work? What can they expect? What is their role as self-advocates in this process? And then more commonly, where we come in, Disability Rights California, is when equipment has been denied. We are less likely to work up cases directly, but will provide information and technical assistance about the process, and more likely step in if Medi-Cal says no. Sort of general, kind of global advocacy recommendations, and I may have touched upon some of these already during the checklist. We want clients to know, residents to know their rights and all the options available. Nursing facility has funding. When does that apply? You go directly to Medi-Cal for the funding. When does that apply? We want to find out from the client and from their records, do they have a Medi-Cal share of cost? And then talk to the client about what that could mean to them. Number two, the care plan is also critical to this process. It is hard to ask for equipment that is not supported by the care plan that was designed by the facility. And so Medi-Cal, when they review requests for equipment, will look to that care plan to see, did the facility assess that the client has the ability to do the activity or activities that the equipment would help with, or not do those activities. That doesn't mean that everything that's in the care plan is comprehensive or accurate, which is why as advocates it's important for us to review what is included in the care plan. And if it's something is missing, to advocate for the item, or for the impairment, for the detail about the client to be included and amended into the care plan. We want to see a connection between the equipment and that care plan. And the same goes with checking the care plan for thoroughness, comprehensively. Are all the facts about the client in the care plan, and are they accurate? Number 4, there are 2 standards that we need to know about when asking for equipment. One is the Medi-Cal medical necessity standard, and that's a very narrow standard that focuses only on the physical and medical needs of the client. And I've provided the language of the standard at the end of the presentation. But there, Medi-Cal will scrutinize requests for equipment, and only are required to authorize equipment when the equipment will alleviate severe pain or prevent significant disability or protect life. And so it's important here in standards to keep an eye on the adjectives. Severe pain, not just any pain, severe pain, significant disability. So for example, my client with the cerebral palsy, he had a history of stage 4 pressure sores. He had the contractures upper and lower, the poor hip flexion, the scoliosis, and was already in severe pain. And we had to, the client needs to articulate what their pain level feels like. When is that pain triggered? Or is it constant and chronic? And for this client, his seating position was everything. If he did not have proper cushioning and sat, his pressure sores were the back of his legs. If he did not have proper cushioning there, the pain was excruciating. If his torso was not supported properly, he had excruciating pain because he didn't have the muscle control or the skeletal support to align him properly, to sit up straight, to support his body weight. And so there, are facts centered around what I'm describing. If he is placed in a standard off-the-shelf chair, he will sit at a 45-degree angle, flopped over, because he can't sit up straight. If he is in a custom wheelchair that has proper back support, then that piece of equipment, the back support, will do the work for him, will alleviate him from having to use energy to sit up, and also has the benefit of, when you're properly positioned, of aligning your organs internally as well, so that they can do their job. So those are some examples of arguments that can be made, but also to keep the eye on the details and the standard. But with nursing facility residents, we also want to keep an eye on the broader Federal Nursing Home Reform Act standard. This standard looks at the resident as a whole person and doesn't just look at the physical. The key language, again, is attain and maintain the highest possible, mental, physical, psychosocial well-being. So there, it's not just important that the client be able to sit in a supported fashion, but it is equally important that he have a wheelchair that makes him mobile so that he can move around the facility, that he can leave the facility with his family and friends. As I've already mentioned, it is absolutely fundamental that the medical justification from the therapist, from the evaluator, has the details, but also makes the connection between the facts, the disability, and the equipment. It is not enough to say this person has cerebral palsy with severe contractions, upper and lower, scoliosis, and poor hip flexion and paralysis. What is absolutely necessary is the reason, the connection, the because. This person has these disabilities impair the person, it prevents this person from completing the following activities of daily living. They need this particular equipment to facilitate performing those activities of daily living. We tested different types of wheelchair bases. I pick and recommend this particular model for the following reasons. I exclude the following models because they don't meet the person's needs, and here's why. I recommend, a tilt in space versus a reclining wheelchair because this person doesn't have good hip flexion, and so if you put them in a reclining chair, their hips aren't going to open up anyway, and it will hurt. If they're in a tilt in space, the tilt in space will move them backwards to relieve pressure and meet that client where they are, how their body position is. It's also important and required that the expert mention that the equipment recommended is the least costly equipment that will meet that person's needs. And this is absolutely important, especially when the cost is high. It's a power wheelchair that costs $15,000. Or the wheelchair base is not that expensive, but the seating system is expensive. Why was this particular brand and model and part picked versus a different model, brand, or part? Why is this gel cushion needed versus a less expensive gel cushion? What is it about this brand? So, for example, I have had physical therapists say, I'm recommending this brand of gel cushion. It is $20 more expensive or $100 more expensive, but the studies show that it is well worth the money because the materials are stronger and they're more durable, and the cushion won't have to be replaced as often. So it's an investment, for example. A good source of additional information and guidance about preparing these letters of medical justification can be found at Neighborhood Legal Services Assistive Technology Project, and they provided a link to a specific publication that I thought would be helpful to you. So I've mentioned it already, but here is the law about the Medi-Cal medical necessity standard. So again, the protect life, prevent a significant illness or disability, or to alleviate severe pain. We do not have to show all three, it's an or. That's state law. And here is the standard under the Nursing Home Reform Act, the NHRA, which is broader. While it is correct to focus on the broader nursing home standard, effective advocacy focuses on the narrower Medi-Cal standard as well. and shows that both standards are met. Because we want to show that the resident will be benefited, if it's correct, in this broad way, that psychologically they'll benefit as well, not just physically. And so those facts are really important. But effective advocacy will say also, and by the way, the Medi-Cal medical necessity standard is also met. Appeal rights. So I mentioned that one problem often is that the resident is not provided information through a notice of action, and that residents have the right to receive a notice of action from Medi-Cal explaining the action that Medi-Cal is going to take. Medi-Cal recipients have a right to request an appeal within 90 days of the date of the notice of action. And where a resident does not receive a notice, they still have the right to appeal. And an advocacy measure would be to advise the client to say that they have good cause for asking for the hearing now because they didn't receive a notice of action. So that should waive the 90-day limit if 90 days has passed. Sometimes clients don't receive notices of action, but 90 days haven't passed, so they're still within the time frame to ask for a hearing. I'll stop here for, let me go backwards for a moment. I'll stop here for questions. I've covered a lot of terrain in this last section. So I see there's, let's see, a few questions. Let me back up here. Okay, I've got one from Alicia. Is there a limit on the cost of a wheelchair paid through the per diem? That would have to get looked up to see what is the per diem rate that has been provided to that facility. So that requires a little bit more research. But remember, since nursing facilities are required to buy non-custom equipment, that equipment may and is likely to be less expensive than custom equipment. So more information is needed. What was requested? Has there been a denial? What are the funds? What is the amount of the per diem rate that is available to the facility to use? Next question. If the reason is that the staff are available 24 hours a day to assist with mobility, are staff required to take the consumer and stay with the consumer at church if he or she wants to go? I don't believe so. And one reason the facility would resist that is they need their staff to be available at the facility, not only to assist that particular resident, but others as well. That the staff's job is to be there, not outside in the community with the person. But again, I would advise looking at the regulations to see exactly what the language is. Next question. Medi-Cal has the rule that we have to wait 5 years for a new wheelchair. If our condition changes 2 years after we get the wheelchair, is Medi-Cal required to provide a wheelchair before 5 years has passed? Or will the consumer have to stay in bed for 3 years waiting for the 5-year rule? I have seen this as well. Yes, the general rule is a 5-year window. But it is also true that our bodies change and our disabilities change, and we may have a new impairment that didn't exist at the time, or one that is getting worse. So the questions, the issues are, what is it about this equipment that it now cannot be used? What has changed with the client? Is the change caused in part or in full by the equipment? Is it an ill-fitting wheelchair, for example? How did this evolve slowly, or is this a problem that, sometimes, clients will say, oh, yeah, this chair will do, because they really, really want the wheelchair, and it's been such a long wait for it, but so we want to know everything about the equipment. How was that equipment selected? Have they outgrown the wheelchair, or has, what has changed, why, when, what are the causes? So the short answer is yes, there are exceptions to the rule, the 5-year rule, but expect more resistance from Medi-Cal because of the 5-year rule. And also, the more expensive that equipment that was purchased, expect even greater resistance. And I think that's fair. I think Medi-Cal is fair to say, we bought this equipment, we relied on an evaluation at that time, and we can't be expected to replace the equipment all the time. And so, the onus is on the client, on the advocate, to show the changed circumstances. The follow-up question is if the change happened due to a lack of physical therapy in the nursing facility. Again, you want to know what happened there. Was physical therapy ordered? Was it ordered properly? Was there an underlying order from a doctor? What was the barrier in the process? If the barrier is the nursing facility itself, it's important to tell Medi-Cal that, because Medi-Cal has an interest in the facilities that they pay in doing their job. And if they are obligated to provide physical therapy, then why wasn't it provided here? Any other questions? So if anybody has questions, we still have about 15 minutes left. I just wanted to point out some resources, and I wanted to thank some people as well. My counterparts at the Disability Rights Network in Pennsylvania have some very good advocacy materials on their website. And also my colleague in Georgia, Naomi Walker, has some good materials as well on the issue of assistive technology and nursing facilities. And this is a topic that I have worked on for many years, and I have been mentored by a senior attorney in our office, Marilyn Hawley, and also by Jim Sheldon, who is, he runs the National Assistive Technology Advocacy Project, which is a project of the protection and advocacy systems nationally. And here are the links for additional resources. The website for my organization, Disability Rights California, we have publications. We have an assistive technology manual, which some or many of you may be familiar with. And in our chapter on Medi-Cal, there's a discussion about nursing facility rights. I have provided you with the link for the Disability Rights Network of Pennsylvania. And you can find their advocacy materials on their website, or also by doing a search for assistive technology nursing facilities, for example. The National Assistive Technology Advocacy Project that I mentioned, that's based in New York, has a website as well, and there is a link for their assistive technology materials, not limited to nursing facility, but very broad topics and extensive materials on assistive technology. And lastly, I provide you a link to the Nursing Home Reform Act if you want to look up specific provisions. The citations earlier in their presentation to California law also apply, and could well serve you as well. Any final questions? In closing, I just wanted to point out the highlights. First determination is the equipment standard, and or is it customized? What equipment does the nursing facility have available? Has the client had an opportunity to try out that equipment? How did it go? Get an evaluation from an independent accredited rehabilitation center. That evaluation should have great detail in it, and talk not just about the equipment needed, but why that particular equipment, what equipment was ruled out, tried, for example, and maybe didn't meet the client's needs, and the cost factor. The equipment doesn't have to be the cheapest or the least costly, period. It needs to be the least costly equipment that will meet this person's needs. If you have any questions later, you're free to contact me. You're also welcome to contact my colleagues in the other offices around the state. If it's a matter that really should require an intake and greater follow-up, I may refer you to my colleague in the office near where you or the client is located. But you're welcome to call me or email me with your questions, and I hope that I will be able to be helpful to you. Thank you to CFILC for the opportunity to present another AT presentation, and thank you all.